So I am objecting to the use of the term disputed nominee, because there's no dispute before us regarding the nomination.
Yes, Honorable Habib, there is an issue raised.
Yes, that's what I'm...
And I must give the floor first to the person who raised the issue in relation to which objection is being taken to respond. Yes, Honorable Minority Leader and the ranking member of the committee. This is the issue raised to part of the submission that we have started raising. What is your response to it?
Chairman, first of all, the majority leader is clearly acting in bad faith, seeking to obstruct the rather peaceful processes we have started, and as it were, try to use his numbers to intimidate. Let me ask, the rule he relied on has to do with debate on the floor of the House. There are dark clouds indeed in this country where freedom of speech by mere operation of a supermajority, you cannot even as a member of parliament make your comment. I am not moving a motion. I am not debating. Please, Chairman, the rule he relied upon. Is it this situation where people move from here and there to create confusion and create their own jurisprudence must come to an end with respect. Interruption of debate. That is, if you go to page 70 or the 122, the title there, the subtitle, interruption of debate. Debate may be interrupted by a point of order. And then he says that I am debating. Who is debating here? Mr. Chairman, if the majority leader has anything to say in opposition to my opening remarks, he has a right bona fide as a leader of government business and as a leader of the House to also state his submission. I have seen him with his written submission, be it for his opening remarks or see that to you as a chair of the committee to read it for answered. But this process where, as it were, try to use it to deny you, don't say this. So every line that I read, he will censor it and say, you use this word. Mr. Chairman, we are not going to make any progress with that. Again, the 1, 2, 3 that he relies upon. He says that the conduct of the Speaker, the Chief Justice, members and Justice of the Superior Court of Judicature shall not be raised in Parliament except upon a substantive motion. With the greatest respect. Have I raised any issue that is situated within the context of 123.7 to warrant this so-called objection? Chairman.
Honorable members, can we have some order?
Chairman.
Honorable members, can we have some order and listen to the minority leader in silence?
Chairman, we are here to discharge a civic duty and responsibility. We are political actors who have our political views on matters of national interests. The matters giving rise to the nomination is purely political, and every Ghanaian adult knows this. Your side raised it as a political issue during the campaign. You are going to remove Justice Tokonu as Chief Justice, and that has happened. If in my statement I contextualize to say that disputed nominee, it is our view we hold as a minority caucus. Right? Express it. We have to express it. And that is why I added by saying that this should be a moment of national pride and institutional renewal. Instead, it has become a test of whether Ghana's judiciary will remain independent or fall under executive and political control. Can't I have these bona fides also that have to be obstructed by the majority leader when you have every unfettered right to raise your issues? Chairman, humbly, please control proceedings. Please take charge. Let our respected leader of government business understand that after speaking, after making my comment known on behalf of the minority, he can seek your leave to also make his opening remarks. By the way, by way of conclusion, this is not the first time a leader in the minority is having this opportunity to make opening remarks. It predates me. From J.H. Mensah's era, he and J.H. Owusu Achampong, all the way to Alban Bagbin, MP for now Dole Kalio, and minority leader as he then was. The videos are there. Hansard is there. The Honorable Bagbin had unfettered opportunity to make his political statement on behalf of the minority, and they were not stopped on point of order. It got to Chairman Sabonsu, it got to Harun Edrusu, and recently, my own respected colleague, Dr. Kasiel Atufosen. The records are there. Let's not create a certain impression as if all it is you are majority, so we cannot even say a word. We must have our rights. These are far right. We will state them, and you would also have the opportunity to state them for the record. Please, let us have some more decency.
Honorable Minority Leader, your point is made. Yeah, yes, you have listened to the response.
Right, Honorable.
Honorable members, it's not every issue that will necessarily call for the chair making a ruling. But honorable members, I indicated as a preliminary issue that let us all operate within the rules. Honorable members, may I add that we need to also observe the principle of brevity. Yes, what do you have to say?
Chairman, if you read rule 1233, 1233, where in the opinion of the speaker, the words of a member used in a speech, and it doesn't matter whether the speech is at plenary or at committee, a speech is a speech in Parliament. So where in the opinion of the speaker, the words of a member used in a speech are offensive, abusive, insulting, blasphemous, or unbecoming, impute improper motives, or impugns the integrity of a member or any other person, the speaker may order that the member withdraws those words or withdraw and apologize. Mr. Speaker, when we came into this chamber, this committee meeting room, and you started, you referred to the nominee as Chief Justice. When you refer to the nominee as Chief Justice, the minority objected to the reference to the nominee as Chief Justice and said that he is not a Chief Justice, he is a nominee to the post of Chief Justice, and so you must refer to him appropriately. Or acting Chief Justice, because he's also an acting Chief Justice. And an acting Chief Justice is a Chief Justice. Now, he has referred to the nominee as a disputed nominee. Disputed nominee. Disputed nominee. You are in court what? Are you in court litigating his nomination? No. Are you in court disputing his nomination? You are not in court challenging his nomination. So to the extent that you are not in court challenging his nomination, there is no dispute about his nomination. If there is a dispute about some other action. So you have no right to look him in the face here before this committee and refer to him as a disputed nominee and expect me to sit here and not respond. So, Mr. Chairman, pursuant to our own rules, he has to withdraw and apologize to him for referring to him as a disputed nominee when he is not a disputed nominee.
Chairman, let me.
Honourable members.
Chairman, he has had two opportunities to make a point. Let me respond to
Honourable members, Honourable Minority Leader, listen to what I will have to say.
Okay.
Please proceed and raise your issue. Avoid the use of disputed Chief Justice. Once I do not have a right to refer to him as a Chief Justice, but Chief Justice nominee, let us all observe that rule and refer to him as such.
Let me be unequivocally clear. The minority in Parliament objects to and unequivocally condemns the coordinated campaign to subjudicate Ghana's judiciary to political domination. Chairman, the facts speak for themselves.
Chairman, I object again. I object again.
On the 22nd April,
I object again, Chairman.
On 22nd of April,
I object again.
2025.
Chairman, I object again. I object.
Hold on. Honourable members, I think at this particular point, I must place on record that I have admonished that we should all operate within the ambit of the law. Honourable Minority Leader, be guided by Order 103D, and then let's make progress. And Order 103D, if I may read, to serve as a guide to all of us. It states that a motion shall relate to a definite issue and not revive the consideration of a matter which had been considered in the same meeting unless new matters have arisen. Honourable members, by necessary implication, whether a motion or not, the principles of res judicata will not permit us that a matter that has been raised on the floor resolve to its finality would be permitted to be raised at a committee meeting. So, Honourable Minority Leader, refrain from anything that is relating to sub judice rules and let's make progress, with all due respect. Because Speaker has dealt with this matter, I have also personally dealt partly with this particular matter, with all due respect.
Chairman, the facts speak for themselves. On April 22nd, 2025, Chief Justice Gertrude Araba Isaba Tokonu was suspended as a result of a prima facie determination by the Council of State as contained in the public announcement made by the executive. We, the minority, hold the view that the subsequent committee that was set up under the chairmanship of His Lordship Gabriel Scott Puama to trial the Chief Justice amounted to a travesty of justice.
Chairman.
The removal
our rules are clearly offended.
in the
Our
language
rules are
of
clearly
judicial
offended.
accountability.
Because the rules I just read clearly offend that.
But
The rules clearly are offended. Chairman, the rules say that the conduct of the speaker, the Chief Justice, members and justices of the Superior Court of Judicature shall not be raised in Parliament except on a substantive motion. He has just raised the question of the conduct of a Supreme Court judge who chaired the committee. And he describes it and the conduct and what the justice did as a travesty of justice. He has raised the conduct of that judge. He has. And the rules are clear. And I can assure you that I will not allow you to breach any inch of the rules today. No inch of the rules will I allow you to breach.
Let me respond to him. Chairman, let me respond to him. Chairman, let me respond to him.
You see, I cannot go and be giving you the opportunity when the person who is speaking is in the process of responding to the issue.
It doesn't fit in the rules.
Yes, Honourable Minority Leader, you have the floor.
Mr. Chairman,
Honourable members, order. Honourable Oman, order.
Mr. Chairman, let me make these preliminary comments before I address.
In response to...
Yes, before I address, I've made an observation. The learned Attorney General knows how much I respect him. He knows how much I respect him. And this must be reciprocated by him. When the respected learned Mahama Yariga, leader of government business, was raising his objection, I remained quiet to listen to him because I know that decency requires that we listen to each other in silence. We are lawyers, and in the East, we must demonstrate that practice in Adaba for people to know that we listen and respond. So please, unless there is another plan that I don't know, but whatever that is happening today, history is watching. Now let me respond to my respected colleague, the majority leader. Chairman, it is his contention that my reference to the committee's work amount to attacking the conduct of its chair. With the greatest respect, I need to be listened to, and he has to pay attention to language as used in context. For the avoidance of doubt, I am repeating that the minority holds the view that the committee's work resulting in the removal of Her Ladyship, the Chief Justice, amount to travesty of justice. It is a view we hold. It does not offend Order 1237. Order 1237, with avoidance of doubt, provides the conduct of the Speaker, the Chief Justice, members of Parliament, the Chief Justice, and Superior Court Justice of Judicature shall not be raised in Parliament except a substantive motion. Now, the distinction must be made. Respected Ayarga, please, bear with me. I've listened to you. The distinctions must be made. Your work in the regular official duties and a critique thereto must be distinguished from personal conduct that one would consider as misbehavior or stated misbehavior. I am not, with the greatest respect, impugning the person of the reputation of my Lord Puaman, who I voted for under the influence of Honorable K.T. Amon. When all the odds were against him, I have nothing personal against him. Because even where there were personal issues that people were attacking his reputation, I was one of the few who stood.
Mr. Chairman.
So I'm not here to attack him.
Mr. Chairman.
And he knows I won't
Mr.
attack
Chairman.
him. The caucus is talking about, please, Honorable Ayarga, let me finish. You were allowed to make your point.
Yes, but Honorable
let me
Minority
make my
Leader, just be brief.
Very well. The committee's work is what we are expressing an opinion on. And we are using very civil language to say that what it did amount to travesty of justice. It's as simple as that. So let me proceed. Chairman, unless the majority leader intends to frustrate everything that the minority has to say by way of its opinion, when did Parliament reduce to this? When you have the right to say your own, you are the leader of the House, you have unfettered right to rebut. That is the debate we even have on the floor. When there's a debate, you take note. Where you think you disagree, when it gets your turn, you should also say that the committee's work did not amount to travesty of justice. Simplicity. But this issue of one line, point of order, next line, you are marking, don't say this, don't say that. Where are we heading to? The judiciary criticizes the government and members of the public where they disagree in their ruling. We,
Honorable
members of the
Minority
public,
Leader, kindly
criticize
conclude for me.
the work of even
Please
the
conclude for
judiciary.
me. Conclude
So
for me.
I beg you, leader,
Conclude.
we all agreed, Chairman, you
Conclude.
know.
Conclude.
Right. So let me proceed.
Honorable members, I have listened to the majority leader.
Travesty of justice is now
I have listened to
an issue we don't. What is this
minority
overprotection?
minority leader. Honorable members, we should be guided by the principles that if there is an issue on the floor of Parliament which has got to do with another who may not have the opportunity to respond to it, such a thing should not be made on the floor. Now, though Justice Gabriel Puama is here in person, at no point will he have the opportunity of responding to any issue raised about him. None of the committee members will have the opportunity here and then to make comment. Therefore, for you jumping into a conclusion to say that their report amount to a travesty of justice without any of them having the opportunity to respond offends our rules. I will consequently order that anything in relating to the committee and Justice Puama should be expunged from our record. That is my ruling.
Chairman,
Kindly proceed.
Chairman, let me protest the rather unacceptable, consistent attempt by the majority leader to obstruct our side's remarks in this process. I know he's your leader, but Chairman, this is unacceptable. That's it. I will proceed. Yeah. We hold a view that the removal of Her Ladyship Justice Gertrude Araba Isaba Tokonu was cloaked in some opaque circumstances unacceptable to the jurisprudence of our country.
Mr. Chairman. Mr. Chairman.
Mr. Speaker, Mr. Chairman.
Honorable Minority Leader, you know the rudiment of the game. If you don't want interruptions, let's go by the rules. Other than that, the chairman will be compelled to listen to the person and make ruling.
This one is friendly. Opaque. It's friendly.
Yes, Majority Leader.
Mr. Chairman, please. Mr. Chairman, if the minority, led by the minority leader, were to walk out here and invite all the journalists, they could describe the work of the committee in any language. In any language. Nobody. Freedom of speech. But before this Committee of Parliament, the rules are clear. What you can raise and what you cannot raise, and how you can raise it. I'll be surprised if after all these years in this Parliament, you don't understand those rules. I'll be surprised. Yes, I intend to be offensive because he has told me that I am here to deliberately obstruct the minority. What did he say about that? To describe my conduct here as deliberately obstructing the minority when I'm trying to keep him to the rules. When you say the conduct of a judge, we're not talking about the personal conduct, who he slept with and who he didn't sleep with. We're talking about his work, how he conducted his work. You are saying that the committee conducted its work in an opaque manner. That's what you are saying. In darkness, that's what you are saying. And that the outcome of their work is a travesty of justice. That's what I'm saying. And you are not in court challenging the conduct of the committee. You are not. You as a person, you are not in court challenging the conduct of the committee. You know the rules in the Constitution regarding the work of the proceedings. You haven't shown at any stage that the rules in the Constitution governing the work of the committee have been breached in any way. How can you come and sit here and describe the work as opaque, travesty of justice, and improper removal, and etc., and expect me to sit here and allow you to do that? You are clearly violating the rules. And when I try to guide you how to go about your work, then you say that I'm trying to obstruct you.
Honorable Majority Leader, you've made your point. And again, if I'm called upon to do a ruling, the rules are clear that we should refrain from the use of offensive language. We are here for the purposes of vetting. A situation where the process will be used to describe the work of a committee to be opaque, meaning it was done in darkness, is offensive. Therefore, I would order that same be expunged from the record as if it doesn't exist. Honorable Minority Leader, proceed.
Chairman, with respect. Chairman, with respect, he raised the objection. You didn't give me the opportunity to respond. And you're saying that you have ruled. I mean, what is the fairness in this? He just raised the objection. He didn't refer to any rule this time. This time, he didn't refer to any rule. And then he says that we should go and do press conference.
Honorable Minority Leader, kindly proceed.
It is our contention that the process leading to the removal of Her Ladyship Justice Araba Isaba Tokonu was unfair, it lacked due process, it did not adhere to any constitutional procedure.
Chairman,
we continue.
I hope, Chairman,
to say,
I hope, Chairman, that persistently violating the rules of this House is a breach of privilege. You know that. Persistently violating the rules of this House.
Chairman, we Chairman, I need
Minority
to,
Leader.
he's made a point. Let me make a point with respect to you.
Honorable Minority
Chairman,
Leader,
let me
if you
make a
can
point.
hear me out,
Yes,
maybe the point that you want to make, you may realize that it is not necessary. Honorable members, let's have it in mind that we are not sitting here as a committee over any decision made by another committee or a court of competent jurisdiction. So bringing same or making same as a subject matter of discussion, with all due respect, this is not fair to members of those committees and those who presided over those cases. So if we are playing by the fair principles, please let's refrain from all those things and be guided by our rules in raising our issues. Minority Leader, you just spoke about fairness. So is it fair that a committee that is not before us, their rulings are brought here and described in a manner unwarranted by our rules? So with all due respect, this will clearly be in breach of natural justice. We don't have the opportunity of the people being heard. So why are we commenting on them? So please, let's proceed. You can give your remarks, but be guided as such. Yes.
Thank you, Mr. Chair. Permit me to enter this discussion. I think that, Mr. Chair, you have to look at this, the context within which the minority leader is making this speech. You have to recognize that there is a background to the nomination of the nominee. And it will look very odd that we can have this conversation, the vetting of the nominee, without reference. It appears that there is a gag order. Mr. Speaker, the minority will have its say, but the majority would have its way. So, Mr. Speaker, what is wrong? We've spent almost 1 hour going back and forth on this simple matter. And I think that it is important that the minority leader is given his opportunity to speak. Then the majority leader can set the record straight if he thinks that he has said something that is. So I think that we should allow the discussion to flow. Mr. Speaker, it's been 1 hour.
Order.
We are still going back and forth.
Honorable Tampuli.
Let's with respect,
Honorable
Mr.
Tampuli.
Chairman, thank you very much.
In this house, we play by the rules. Now, tell me, at vetting, in raising a preliminary issue, and preliminary issues are not questions for the nominee to provide an answer. Then you bring the work of another committee entirely to vetting, describing it in all sorts of ways. Should this be permitted or it should not be permitted? So if we are all operating within the ambit of the rules, we will not have any problem. That is where the problem is coming from. The whole world is watching us. So I believe you agree with me that it is not proper, by way of preliminary issue, a work done by a committee should be brought at a vetting and be raised as a preliminary comment.
Mr. Speaker, with respect, I'm not sure the leader is re-litigating any issue. What the leader is doing, with respect, as far as I'm concerned, is that he is making commentary. That is his view, his judgment. And it is the view of the minority. And I think that it should be allowed to land. Then the majority leader can speak. Mr. Speaker, I think that, look, if we are going to be too, more or less fastidious about what he's saying, we can't make progress. With respect, Mr. Speaker. Thank you, Mr. Speaker.
Honorable Tampuli, if we want to make progress, I think we can make progress. But if you deliberately don't want to make progress, we are deliberately trying not to make progress. Honorable Tampuli, guide me by the rules that govern the House. The actual rules that allow that in making your preliminary comment, you should be allowed to describe a work of a committee in a language in which the minority leader is describing them.
Mr. Speaker, in this standing orders, Mr. Speaker, may I refer you to Order 5?
Yes.
Order 5 with respect, Mr. Speaker. Order
Yes.
5.1, subject to the provisions of this Constitution and any other enactments. Where there is doubt, these rules shall be interpreted by Mr. Speaker. 2, in any case not provided for in these orders, Mr. Speaker shall decide on the procedural question. And finally, 3, in exercising the power conferred under this order, Mr. Speaker shall act in accordance with the Constitution. So we think that what you are doing,
yes,
it may not be provided for expressly.
No, but
so
what you are saying,
what you are doing
yes,
amounts to being guided by Order
the
5.
rules, yes.
You understand?
Yes.
So, Mr. Speaker, even under the Constitution, under
so you agree with me that I'm operating within the ambit of the rules?
With respect, Mr. Speaker, under Article 297, the Constitution even contemplates an instance where something will not be provided in the Constitution or any other law. And they say the Parliament. So, Mr. Speaker, there are penumbra areas, there are gray areas where you fill in. And I think that you have to exercise your discretion to allow the minority leader to land. Because what he's saying doesn't amount to raising issues. Mr. Speaker, he's not here with a substantive motion to raise questions about whatever it is.
Honorable Tampoli.
We are dealing with
Honorable
comments.
Tampoli, I thank you very much for reading Order 5. I think Order 5 is clear as to why I am behaving the way I am behaving. But I can assure you that most of the things that the minority leader has said that I rule again, they are specifically and expressly provided for in the rules. In the rules. So minority leader can go ahead and make all his comments without touching on anybody who is not before us. He knows. Yes.
Thank you. Thank you, Mr. Chairman. Chairman, I want to draw your attention to Order 24B and D. Mr. Speaker, with your permission, I read Order 24B, that the Speaker shall promote concessions on matters under consideration in the House, and D, protect and preserve the rights of members. Mr. Speaker, I'm drawing your attention to this because the minority leader under Standing Order 24B, D, have a right, and which you have given him the permission to make his opening remarks. So I'm appealing to you to protect and preserve that right as it is in our standing order. And also, Mr. Chairman, the Order 24B, that you should promote concessions on matters. If majority leader think otherwise, minority leader think otherwise. Majority leader, after majority leader's statement, can also make statements if there are things, and correct some of the things that he thinks is wrong. Then we can make progress, Mr. Speaker. Thank you.
Honorable Minority Deputy Whip, it is not only the right of the minority leader that is supposed to be protected. The right of everybody is supposed to be protected. The right of those committee members are also supposed to be protected. So don't take it that I am violating the right of the minority leader in any manner whatsoever. That will be a very wrong impression. And let me state that anybody who wants to enjoy his rights should know that the beginning of your right would mark the end of somebody's right. Thank you.
Chairman, and keep to the rules because I will object to anything that violates the rules.
Mr. Chairman,
Minority leader, don't be preemptive. Majority leader, don't be preemptive. So go ahead.
Chairman, 7 separate proceedings across 3 jurisdictions. Our own Supreme Court, the High Court, and the ECOWAS Court of Justice now challenge the constitutional validity of that removal. Not one has been heard on its merits.
Mr. Chairman.
Yet, while these cases remain pending,
Mr. Chairman,
while the very question of whether a vacancy exists remains
Mr. Chairman,
sub
I
judice,
object.
there is a nomination
I
to
object.
replace
I object.
Can have the
Gertrude
floor.
Araba Isaba Toko.
Honorable Minority Leader, hold it. Majority Leader, you said you object. What are you objecting to?
Mr. Speaker.
Order.
Our rules are very clear on pending matters. Our rules are very clear on pending matters. And it says in Order 103F that a motion shall relate to definite issues and not be the subject of an action on which a judicial decision is pending in such a way as may, in the opinion of the Speaker, prejudice the interest of the parties to the action. Mr. Speaker, you see, when you keep saying motion, these rules guide proceedings in chamber, and mutatis mutandi, they apply to the work of committees as well. The rules are clear. What you can't do in the chamber, you cannot do in committee. So the rules are clear on pending matters. So you can't come here and comment on pending matters in a way that will prejudice the interests of the parties. So we stay away from random commentary on pending matters. We even don't refer to them. It's clear. And I'm saying that you are a senior lawyer, you know. You've been in this house, you've been a majority leader, you've been a minority leader, you have lived through all the rulings in these matters. Pending matters, we should stay away from them. The conduct of judges, we should stay away from them. You have so far not impugned the process of nominating the nominee and submitting the nomination to this House, and the process of referral by Speaker of the nominee to this committee for the committee to do its work. Those are the legitimate matters that you can raise, and you haven't raised them. So all the questions about what happened, if you had waited and we started proceedings, and you throw a question to the nominee to get his views on the matter, I may not object. But you can't just be allowed to run down everybody and get up and walk because you are Afenyo Makin. Why? It will not be allowed. I am going to look, this whole issue about you making a preliminary statement, show me a rule that says that you have a right to make a preliminary statement. Show me in our standing orders anything that says that you, Afenyo Makin, have a right to make preliminary statements. You don't. Listen, we developed it as a practice. We developed it as a practice where normally the two leaders may make welcoming statements and general open statements, but you have converted it into a platform to do a press conference where you attack and impugn people and walk away with it. I'm saying that today you will not attack anybody and walk away once I sit in this committee.
Yes, Minority Leader, what do you have to say to it?
I haven't spoken. At least if I catch you.
It gives you the opportunity because he is on the floor. Tell him, when he said I should hear Tampuli, I heard Tampuli. Should I hear another play? Should I hear another play?
Yeah. You can hear him after that. I come and respond to him. I know if you have anything.
Yes, Honorable Anodonpre, what do you have to say on the issue raised by the majority
Speaker,
leader, Honorable Mahama Ayarga?
Well, initially I didn't want to comment. We thought we should. Speaker, we in leadership have a role to play in helping you shepherd and guide this process. How does it look that the Chief Justice nominee is before us and this whole process is being reduced into a banter between the majority leader? It's been reduced into this. It's most unfortunate. And I'm surprised at some of the issues being raised by the majority leader, saying that, show us the rules that says that when there is vetting, you should be allowed to make comment. We are not only guided by rules, we are also guided by practice. Show me the rules that tells us that every Friday you should be standing behind the dispatch box and presenting petition. There are no rules on that. But it's part of our practice. And majority leader will respect you. You know this. So don't keep referencing that, saying that, show us the rules, show us the rules. It's not just about the rules. It is also about our practice. Now, the very rule you referred to, 103, when you said it could be applied mutatis mutandi, I think majority leader, you are wrong. The rules were made with specific functionality. And the 103 you quoted is on admissibility of motion. No, it's motion. And it's giving us conditions for admissibility of motion. So when you read the heading. So you are interpreting the rule to suit your understanding. A while ago, Tampuri just referenced Order 5 and says that interpretation will be done by the speaker. Allow the speaker to lead the process. Allow the speaker, the chair, to lead the process. All of us are here to support, to make sure that these things are done. But the way you are positioning yourself is giving a wrong impression, and the public is watching. You will not even allow the minority leader to speak. And you are marking every sentence. And we are here saying that is normal. Why don't you take your note? When he's done, then you can present your version of the truth.
This law teacher started marking his sentences longer.
Okay, waiting for Muguso Eshe, Ago 96.9 FM, the YouTube channel. Ago FMGH, Ago FMGH. Omadi answer, obe subscribe to page, you know. Now, fi wa share link, you know, now fi afu Francis, no. Etumi enya kwenya, etumi ashebi. Omadi answer or comment in Sosuno, obi to me, edia toase, edia maye. Kaise a vetting of Chief Justice nominee, era Justice for Baffoe-Bonnie. In Pimpri, were acting Chief Justice. Na Ghana man, His Excellency John Dramani Maham Abodidi as substantive Chief Justice in the SSM Nashimi Fee appointment committee, Erena Wotumi at Tunano. Na ene an appointment committee no say Omobeto Tunano. Tia Case videos are reading nano. Vete no, and our Hibino. Na in Pimpri no, dia vete Nankasankasano into me and share as yet. Nina Nyama Bakumini as a maintain one city to me a PM or honor. Usually, a do vetting say as a preliminary comment about. Na you're a federal marking, a minority leader, a crazy, a preliminary commenter, or referred to a year for justice for Baffoe-Bonnie, say, or your Chief Justice, the position is in contention. Not just a such as a Papa Nukranidia, or one of our veterans here to Tunano Crano, and San Francisco said the position now of veterans here to Tunano, our court. Just in contention, our court, and then a minority leader said that be on Tias here because there be any one more. If we say John President, a boy, a year for Baffoe-Bonnie Dino, will be their court to say one penny Emma Papa and your Chief Justice. Intino, be being one of say court in some of court nano. And ne papa no dia ya bon enihwe ohwe court in some court no former Chief Justice Gertrude Araba Isaba Tokoni ono na wa raise issue say aban ya pamono as Chief Justice there said the be an entitlement in sabekenti ya man nkonkwatena Supreme Court so as a judge and on the court inti cases be in senior court na no it's not about say one peneso so be Chinchati when Chief Justice Nebuno, a banner entitlement, one famano, and Alphys Grand, your man court, your judge. I was Supreme Court, say a female minority leader ever withdraw that comment to say Chief Justice the position is in contention any ever to no and then I say I'm a tremendous el coso or machine be fear ya say the vet and shas cry but yes a comment preliminary comment no and who both contention because now my majority leader Mahama Yariga HS as far as say where you're concerned and nominated but a meeting should be there. One mark point a year minority leader. Fino marking one yet you were pay. I vetting me a trip, you know, or it's me at your pay, card your pay, intimidating for card your pay. By this time around here, Chief Justice you war bet Namubi, a copy some movie, and on and on. Into no that random goose so edge, no. Into you better recommend them as a washer, no. Share page, no. Now for Francis, so while Queen, and I say, baby, for Francis, no. Into me and she be high, I go 96.9 FM. Ago 96.9 FM. They are free.
Multiple Supreme Court proceedings and High Court applications are finally determined or withdrawn. And that, in the interim, the Business Committee reprograms the business of the House. Accordingly, the Appointment Committee stands down any scheduled vetting related to the nomination and that the Attorney General and Minister for Justice be summoned pursuant to Article 103 of the Constitution to appear before this House or before such committee as the House may designate to provide a comprehensive briefing on the status of all pending litigation relating to the removal of her ladyship Justice Gertrude Araba Isaba Saki Tokonu, including but not limited to A, the identity, jurisdiction, and procedural status of all such proceedings. B, any provisional measures, interim orders, or conservatory orders sought or granted. C, the relief sought in each proceeding and their potential implications for the office of Chief Justice. D, Ghana's international obligations under regional treaties relevant to the ECOWAS court proceedings. E, the government's assessment of potential legal and constitutional implications of proceeding with the appointment of a successor Chief Justice while such litigation remains pending. And F, any other matters relevant to Parliament's informed exercise of its constitutional functions under Article 1141. Applicants of the motion.
Well, hold on. Let me hear you, Honorable Habib. What are you objecting to?
Chairman, Parliament and parliamentary proceedings and practices. A member is not to address the House. What Honorable Roxon is doing is addressing us. Whatever he's reading, Mr. Chairman.
Honorable,
Mr. Chairman, but
you are completely out of order.
To us, Mr. Speaker.
You are completely out of order.
So, Chairman, no, he should stop.
It is only when a supplementary question is being asked.
A motion that the Speaker has ruled.
Would you listen to me,
reading the
Honorable
motion
Habib?
on the floor.
Would you listen to me? It is only when a supplementary question is being asked that you don't address the House. So you are completely out of order. Honorable Minority Leader, may I have your response?
Chairman, I'm not done.
Okay,
I'm
hold
not
on.
done.
Then conclude.
Yes.
Conclude.
No, I'm not done.
Then conclude.
So, Mr. Chairman, these were the terms of the motion the Minority Leader and his group filed. In the course of considering admitting this motion, Speaker determined that the motion cannot be admitted. Now, the Minority Leader, as ranking member of this committee, is using a backdoor approach. He has rehashed the terms of this motion contained in a speech, and he seeks to read that speech before this committee.
Honorable Member,
it cannot be done.
You've made your point. Yes, Minority Leader, let me hear you.
Chairman, with respect, thank you for the opportunity. Let me first respond to the issue raised by the respected Majority Leader, which issue he anchored on Order 103F. For the avoidance of doubt, I would repeat the provisions in the said order. A motion shall relate to a definite issue and not be the subject matter of an action on which judicial decisions is pending in such a way as may, in the opinion of the Speaker, prejudice the interests of parties to the action. These are my views on this. First of all, we are not dealing with emotion. But granted that, as he put it, this provision that deals with conditions of admissibility of motion should be read and construed within the context of my preliminary comment, then I would even yield to that and then ask a question. Was he not the same person who, when the minority brought a matter up on the floor regarding the mass dismissal of public sector employees, he came out with the preliminary objection to the fact that the matter was in court. Henry Nana Boakye has filed a suit at the Supreme Court. Therefore, Parliament should not even discuss it. Whereupon, the Speaker upheld his objection, in spite of explanation to the fact that the matter had nothing to do with the suit in court. Now, even today, now he says that my reference to cases pending at the ECOWAS court, at the Supreme Court, at the High Court, amount to prejudicing the outcome. Really? But we have a nominee before us. The nominee with the power to empanel. In fact, the empaneling of the court for the determination of injunction application was done swiftly. As we speak, per his own words, the court has not empaneled the Supreme Court to determine the substantive matters before it. Recently, we heard the Attorney General even applying to the court for leave for extension of time to file a defense. We have a nominee before us with the power to empanel. He has not empaneled. If we are now interpreting 103F properly, then it rather even applies to the case of the minority that this matter should be placed on ice, because the nominee is likely to be conflicted, especially when he is the one to empanel. Two, that the substantive matters have not been dealt with.
Honorable Minority
Let
Leader.
me finish.
With all
Chairman,
due respect.
You allowed the Minority Leader. I'm responding
I'm
to his
not asking
objection.
the Minority Leader to raise an issue. Order.
I am responding
Order.
I'm responding.
Honorable Minority Leader.
Let me respond.
Honorable Minority
Let me
Leader,
respond
hold
to
it.
him.
Honorable Minority Leader, hold it. May your microphone be off, Minority Leader.
Chairman, just a second. Bear with
Minority
me.
Leader,
Chairman.
let your microphone be off. Hear
Chairman.
me out.
Very well. I will hear you.
Yes,
and
I'm
then
supposed
continue my
to
argument.
play the fair game here.
If you make your point, we respond.
Honorable Minority Leader,
What is wrong?
please, just
I don't have to
observe
respond.
me.
The Fiamma Post spoke.
Hear
for
what I
almost
will want
20
to
minutes.
say. Honorable members, can there be an order? Order. I don't want to hear anybody's voice again. Honorable members, when an objection is raised, I listen to the objection. So I expect you to respond to the objection that is raised. I don't think in all the objections raised, there is anything in the objection that suggests that the nominee before us swiftly empaneled, acted in conflict. I mean, all those things have not
You've said
been-
that. You've said that. You've said that.
Why?
You've said that. You said that. You said that the nominee
So-
swiftly empaneled the court.
So, honorable members, On this note, I would want him to conclude. I will rule on the matter, then we take a short break and come back and continue with the vetting.
Chairman, with respect, it is my view that if the order 103F that the majority leader made reference to at all is applicable, then it is the more reason for the minority's concerns to be heard. Here is he suggesting that nothing should be raised that is likely to affect the outcome of a pending suit. That is what he says. He says that my reference to matters that are pending before court amount to a situation where I will be offending Rule 103F. If that is the case, then the matter before us is rather more fitting than the argument he's making against me. Because, with respect, we have pending suits for over 6 months.
Chairman,
I have the floor. You've not called me.
Chairman, the rules.
You have not called him. Chairman, you see, Chairman, he puts on the rules.
The rules are clear.
No, it's not.
The rules are clear. The rules are clear, Chairman. The rules. So when you
Just comes in. But you just put on your microphone and speak. Leader, you just put on your microphone and speak. That's all right.
Honorable members, I have stated clearly, the whole world is watching us. You will not have the floor until I ask you to do so. I will consider a situation where you put on the microphone without the speaker asking you to say something as disorderly, and I will invoke the rules appropriately. So we should all take note. Minority Leader, kindly conclude.
So, Chairman, what I am saying in short is that the very rule that the majority leader is invoking supports the contention of the minority. And I'm responding to him by saying that the cases that are pending, that he has a problem with my earlier statement, if we consider this motion, they shouldn't forget that what Parliament is doing, the vetting of the nominee, eventually will lead to the report being moved on the floor.
Honorable Minority Leader, hold it there.
For him to come in?
Yes, hold it.
Okay,
Not for him to come in. I am coming in personally. Severally, I admonish you that a matter that has been dealt with on the floor of Parliament, this vetting committee cannot be constituted into a court of appeal to reverse any decision. Therefore, I will personally not tolerate any of those issues to be read. Now, I accommodated the majority whip, and he read in extenso your motion. So anything that relates to your motion would not be entertained before this particular committee, because for me, that matter, procedurally and legally, is mute. It cannot be raised. So, Minority Leader, kindly conclude.
Chairman, there are two issues that have been raised, and each of them must have a response.
No, you see, when your leader is speaking, and you're asking me to give you the floor.
The majority leader has raised his issue. And then the Fiamakpo also brings in a different issue. So I'm done with him. Let me now address the Fiamakpo's issue, the majority chief whip. The majority chief whip is contending that the minority's motion was ruled upon. Mr. Speaker, Mr. Chairman, we are not here to rehash our argument. We have not brought any argument before the House. We filed an administrative motion, which motion was declared inadmissible. It's as simple as that.
You have to catch the attention.
Now, it does not stop us from stating our views on an important national matter. It doesn't stop us. We are not challenging the Speaker's ruling at this committee. We know what to do. The minority, even when we disagree with the First Deputy Speaker, filed a review application which was admitted, and we started a debate. We are not in any way against any ruling and against any rules. We will use the rules to express our views. So the majority chief whip is completely wrong to introduce that matter. What we are rather saying is that the rule that the majority leader is seeking to invoke to rather stop the minority from exercising its right of opinion on a matter of national importance rather supports the very reason why we had come with a motion to say that let all the matters be determined to bring clarity, because Her Ladyship Justice Arabe Esaba Tokonu has rights, far rights. And what becomes of her when eventually the court determines that all her reliefs are upheld, yes, and then what becomes of us?
Yes.
What
Honorable Majority Leader. Honorable Majority Leader.
You are hearing him?
No, I am the one speaking.
What do you want?
You understand?
Yes.
Please, let's take a cue. Severally, I admonished
Him or me?
that everybody, that anything that has to do with a matter raised on the floor and a ruling delivered by the speakers, including me, would not be entertained. So that one, strictly, any attempt to go into that particular area, I would ask you to stop your submission and maybe go to another area. And probably we may have to take a decision if persistently you've decided not to listen to the chairperson of the committee. So I am pleading with you. You see, with Jerry Ahmed, you catch the eye of the speaker at the right time. You don't expect me to interrupt the minority leader to give you the floor to speak. It is not done in any parliament. So minority leader, if you are done and you want me to make a ruling, I will make a ruling. Then we take a break.
Chairman, with respect, the minority on this committee is ready to assist you through this process. It is clear to us, however, that consistently there is a grand design to obstruct us, deny us of our right to express opinion on a matter of national discourse. We are clear on our minds what the majority is up to. And Chairman, although we know, and it's a fact, that all of you are of the same stock, we, however, think that we should be heard. All these objections that they are raising here and there has one aim, that the minority must not be heard for posterity. They know that if these views get into Hansard, it will come back and haunt them someday. That is all that they are doing. Chairman, it's not a matter for ruling. I hold a view on behalf of my colleagues that you should restrain the majority leader, because it is one too many, very consistently, the statement that I made as part of my remarks that he is invoking Order 103F is neither here nor there. I didn't make any prejudicial comment. I didn't say anything that offends Order 103F. It is very clear what he is up to. Let us be very fair. Let us allow democracy to be at play. They are in the majority, no doubt.
What is the problem?
They are in majority, no doubt. But they should allow us. I'm responding to, you see, Chairman, Chairman,
But you can't be jumping from this issue.
Chairman, what the majority leader is doing, is not fair. He raises his issues. You don't have to respond. When you are responding, he now determines how you should respond to him. The chief whip has spoken. You have spoken. When you are talking, you don't calculate the hours.
Because
Honorable members, order.
When you are talking,
Order.
When you are talking, you
Honorable
don't
members,
talk about the
on
time.
this note, we'll break for cocoa. So it's time for cocoa break.